Yes, Madam President, we're ready to start the meeting whenever you are. Yes, Madam President, we do have a quorum with all members present, especially now since Mr. Quinn has just joined us.
Awesome. Rosie, do we have any public comments?
No, Madam President, we don't have any public comment for
Okay,
this.
great. Moving on to Section 4, approval of the consent agenda items, service retirements, drop entries, drop retirements, training, and board agenda calendar. Before I make a call for a motion of approval of the consent items, would a board member like to pull a consent item for a separate vote? Okay. Okay, hearing no request to pull, I please have a motion and a second to approve agenda items A through E.
Madam President, this was moved by Mr. Brett Bartolotta, seconded by Roberta Spoon, and board members, please cast your votes.
Perfect.
And with all votes in, Madam President, this motion passes 12-0.
Okay, thank you. So this finishes our consent agenda items. Now we'll move to Section 5, Business and Operations. We have one action item and one information item on business operations agenda this morning, starting with the action item staff recommendation to accept the actuarial audit report of the June 30, 2024 valuations. Greg, will you please introduce this item?
Thank you. It's a pleasure to see the board this morning. Thanks for a full board. This is wonderful. As you know, we have the actuarial audit consulting firm Chiron as the plan actuary, and they've been a valued business partner of ours for a very long time. But it is good governance practice to, on an occasional basis, make sure they're doing a great job like we think they're doing. And so we hire an independent actuarial firm to reproduce the results of the latest valuation to make sure that those valuations are reasonable. As you will hear from Milliman, we have Nick Collier and Daniel Wade from Milliman. It's very hard to replicate it exactly, but you want it to have a very reasonably good, close valuation. And a spoiler alert, it was a clean audit. So I'm very, very pleased to hear that. And to take a line from Natasha Kalura when we were talking to the retiree groups, she said, a reasonable audit is actuary speak for great job. So with that, I will turn it over to Nick and Daniel.
All right, thank you so much. Good morning, all. I'm Nick Collier. This is Daniel Wade. As Greg said, we're here to present the results of the 2024 audit on the 2024 valuations for the 3 different plan sponsors. And we
Oh, are you speaking into the mic? I'm sorry, we can't hear you.
My bad. I'm going to start over.
Okay.
So, good morning, all. I'm Nick Collier. This is Daniel Wade. We're here to present the results of the audit of the 2024 valuations for each of the 3 plan sponsors. Oops. So, looking at the blue box, I think Greg already touched on this. The purpose of the audit is to do an independent replication of Chiron's actual work and confirm the results of the valuation are reasonable. As Greg said, it's reasonable is actual real estate with good job. We're never going to say good job for our competitors, but we will say their work is reasonable. So, so we're basically doing the work as if we were the retained actuary and doing all the calculations. As Greg said, they're not going to match exactly, but we do have an expectation they're going to be very close, and we will talk about that as we go along. So moving to the next one, you hired us, so you probably know, but just for confirmation, we're a qualified actuarial firm. I think Milliman's about the 3rd largest public firm in the public sector retirement space. In particular, Daniel and I have over 25 years of experience working with public plans. We work with statewide systems up and down the West Coast and also in Texas and Florida. We also have extensive experience with California plans, so we're very familiar with PEPRA, and we performed, or at least I have performed, over 50 actual audits. Getting too fast. Greg already gave you the spoiler alert here, but I did want to give a quick shout out before I get into the results. Just Greg and his staff were great assistance to us in just understanding some of the intricacies of your plan. So thanks to them, and also a shout out to Chiron and to particularly Alice. I've been on the other end of actual audits, and it's never fun having somebody pick over all your work. So we really appreciate her responsiveness to all our questions. Moving on to the results. As Greg said, this isn't an accounting audit. These things we're not going to match exactly during the myriad of the calculations and complexity of them, but we do have an expectation to match very closely, as I think you would expect that. There's no absolute standard in actual audits. I personally have a kind of a rule of thumb that in the total liabilities, I expect to be within a relative 1%, and on the employer contribution rates, I expect to be within a relative 2%. And if you look in the green box in the middle there, you can see in the actual determined contribution, we are within that 2% and actually quite a bit closer. You can see on the state, you don't have to do the math, I'll do the math for you. We're within 0.3% on the total contribution. And on the funding ratio, which is really a proxy for the liabilities, you can see we matched exactly. So all good there. And with that, I'm going to turn it over to Dan. I would say, as pleasant as it actuaries to hear actuaries drone on, you are more than welcome to ask questions as we go along. And if we don't have any questions, I'll turn it over to Dan.
Okay, seeing none at this time. The last slide, we looked at all the outputs to the modeling and had good matches. Well, in order to really feel good about those matches, you need to also feel good about the inputs to the model. And the first of those inputs is the membership data. For this, we gathered all the same information from SDCERS that Chiron received, and we looked at that census data, and we made sure that it was complete. It had all of the information necessary to do an actual evaluation. We also looked at it for reasonableness and internal consistency. Then we did our own independent data editing, and then we looked at our results and compared them to Chiron. Another thing I want to say about a comparison that we do is we do look at benefit payments, and we look at that in a few different ways. We look at the financial statements for the previous year. We look at the payment amounts on the individual census data fields, and then we also look at the projections for benefit payments into the future, and we make sure that all of those measures are aligned. And in this case, they were indeed all aligned, and we matched the individual census data statistics well as well. And we have the actual liabilities and the normal cost rate. A little bit of before I talk about how well we matched, I want to talk a little bit about the process. We take that same data, we take the actual assumptions and procedures, and we look at the benefit provisions. And with all of these inputs, we're able to project forward all of the future benefit payments that can be expected to be made for current members. That then gets discounted back with the investment rate of return assumption, the discount rate of 6.5%, to come up with an actual present value benefits. That gets split into pieces for past service, the actual accrued liability, present service, the normal cost, and future service. That's all done with the entry age actual cost method, which is by far the most popular in public retirement systems. It's also the only one available for financial reporting, and part of the reason it's so popular is that it produces a theoretically stable level of cost for the contribution rates for the benefits that have been promised. And as we look at the past service, the actual accrued liability, you'll look that we matched quite well, and we looked at it in a variety of ways. We looked at it by employer, we looked at it by status within each employer. We have good matches up and down. We also looked at the normal cost, and that's that cost that's allocated to the present year. And indeed, that can be a little more difficult to match sometimes, but we did eventually get to a good match on that as well, and that's in the upper right-hand corner. A little bit about the methodology. As is also common for most public sector systems, the contribution rate is made up of two pieces. You have the normal cost, and then you have the layered amortization, the unfunded liability, There's a 15-year amortization, and then it's also a little bit longer for the assumptions. And we feel that this is a reasonable approach to the balance of paying off the UAL. These are sometimes conflicting goals, paying off the UAL and having more stable contribution rates. Another thing I did want to mention is that a comparison is done to make sure that at least the interest on the unfunded liability is being paid each year. That way, if all assumptions are precisely met, the unfunded liability will not grow. That, I think, is a good test that's done, and it is actually applicable on the airport side of things. And you can see that we match the actually determined contributions quite well by each employer. Really a good match there, and you can feel good about the amounts being contributed given the inputs to the model. Going to talk a little bit about the member contribution rate. Now, this is an extremely important calculation because this affects how much individual active members are paying into the system. It also has a direct impact on the system itself. And as you're also probably aware, this is a very complex calculation for your system. It's broken into 4 different pieces, and we needed to analyze different sources to make sure that we had the right components. And it also varies by entry age for the city. And we have shown the age 30 amounts here. We did check for other ages and had good matches. Given the complexity and the assumptions that need to be made, we felt very good about our match in this area. Then for the PEPRA plans, it's done a little differently. It doesn't vary by entry age, but you do have the normal cost based on the total normal cost. Some of these numbers were calculated in prior valuations, but we still felt very good about the matches that we had. I'm going to talk now about the economic assumptions, certainly another very important input to the modeling. And for price inflation, the assumption that's used is 3%. And there are a lot of different ways to look at setting the inflation assumption. It's notoriously hard to predict. As you know, even the people tasked in the Fed, tasked with helping to guide inflation, have a difficult time even predicting for it. And what can be done is you can look at historical measures. Now, historical measures tend to vary based on when history begins, so it can be a little hard because different horizons will tell you different things. Certainly, inflation has been very high recently and stubborn. I think it just came out yesterday, 2.9% August over August, which is more than the target. Also more than where it's been for most of the past 25 years, but we did have the high levels in the most recent history as well as in the 70s and early 80s. One thing we look at then, because history can be mixed at best, is we do look at forward-looking projections. You can look at the difference between TIPS, Treasury Inflation Protected Securities, and regular treasuries. And there's something called the break-even inflation rate, which aggregates what investors think will be the inflation over the next 10 or 20 or 30 years. And I looked at it earlier this week. The 10-year was at about 2.35%. The 30-year was about 2.3%. We'll also look at what the Social Security Administration has to say. Their intermediate assumption is 2.4%. Bottom line, the 3% is a reasonable assumption. It's a little higher than most forecasts, and it is, it is still, we feel, a reasonable number. Then we look at the wage and payroll growth. That's done with a combination of the inflation I just talked about at 3% and then a 0.25% for general wage growth, giving us a 3.25% total like the other. It's a little hard to look at history because it depends on if you look at mean or median or what type of horizon you use. 0.25% is a little on the low end, but the combination of 3.25% with one arguably a little on the high end and one on the low end comes up with a very reasonable assumption of 3.25. The COLA assumption, 2% every year, the retirees and survivors get a cost of living adjustment to their benefits, and that's based on CPI, but capped at 2%. There's also a bank. Don't need to necessarily go into all the detail about that, but with a 3% inflation assumption and a bank, most people can expect to get 2% each year, and so Chiron makes the very reasonable assumption, and we agree with this assumption to just use a 2% assumption for going forward. Last but certainly not least, the investment rate of return assumption, 6.50%, is used for this, and this is very important because that's what's used to discount all those future benefit payments to a present value. What's typically done for setting this assumption is to look at the target asset allocation and then look at various capital market assumptions to come up with an median expected geometric rate of return. And Chiron did use this approach. They looked at Aon's numbers as well as a survey from Horizon, a firm by the name of Horizon, and they looked at what the target asset allocation, the capital market assumptions implied for that. As kind of an independent check, an extra data point, we looked at what Milliman's investment advisors, not investment advisors, but investment experts. We have a team of internal credentialed investment experts, and we looked at the target asset allocation and used our June 30, 2024 assumptions. And as you can see on the right-hand side, all of these measures are a little higher than the dashed line 6.5% that's used. And we looked at it over the 10-year horizon as well as the longer horizon. All the economic assumptions are reasonable in our view.
Could I ask a question?
Yes, please do.
We talk quite a bit in this area about generational equity,
Okay.
and the idea that each generation ought to pay its fair share, right?
Mm-hmm.
Not too much, not too little. Mm-hmm. And the discount rate nor the investment expectations factor into that, right? Because if you hit it wrong, then you either underpay, a given generation underpays or overpays, right?
Correct.
So I was struck by your comment in the report on page 4, but also here saying that your analysis supports the investment return assumption of 6.5% as being reasonable, although it is lower relative to most other systems.
Correct.
And then looking at what Aon is telling us as of May last year, that we have a 30-year expected return of 7.45%, quite a bit higher, right? And you've also shown some other places that are a bit higher. Mm-hmm. If we hit that discount rate too low, then this generation pays too much, basically, right? Well,
the future contributions would tend to go down then. That's right.
Okay. So when you talk about ours being lower than most other systems in your report, what are most other systems? Where are they?
Well, here, I'm glad. This is, I don't know if you were setting me up for this, but yes, we have a chart on the very next page where we have California systems in the upper right, and you can see the green bar is SDCERS, and you can see most are at 675 or 7, with the average at about 6.8 for California systems. And you're the green bar, they're sorted from lowest assumption to the highest assumption on the right-hand side there. And so you can see you're the green bar. Also, I want to mention nationally that the range goes more from 6.5 to 7.25. And so the average there is 6.9. 6.5 is obviously, underneath 6.9. And one other disclaimer I want to have on that is that different systems have different target asset allocations. Different systems have, of course, different risk tolerances. So you don't necessarily want to set it just based on what everybody else is doing, but I think that is important context.
Is there anything in this chart that can reflect the funded status of these different plans as well?
Not on this chart, no.
So that's also a factor.
Certainly it could be considered.
Thanks, Cliff. So just continuing this, though, if we were at some point in the future to adjust our investment assumptions to more like the 6.75 or 7%, then the annual contributions in the current years or in the near future years of the plan sponsors and also the members of the system would go down somewhat.
That's correct. I mean, I don't know if you
Yeah.
want to add anything to that, Nick.
Yeah, I mean, I would just add that you're in a very similar situation to most every public retirement system where we had 2 decades of declining expected returns, and you know, it's you know, the old saying that may you live in interesting times is actually a curse, and actuaries kept on coming in and telling the retirement system, lower your assumption, lower your assumption, lower your assumption, which wasn't fun. And now we're finally in a situation where over the last, I think, 2-3 years, where most systems now have higher expected returns than actuaries. I mean, now we're stewing over that, because now, do we tell people to return their assumptions? And I mean, I watched your board meeting in 2023 where you had this discussion, and at that point we wholly agreed with what Chiron said, is like, hey, this was a one-time blip up. Let's hold steady right now. And that's what I've told my clients too. Now we're kind of coming in a situation where there's been a couple years now, so honestly I'm not sure where we're going to go. And in particular, California plans, it's a little tougher because almost all California plans, the investment return assumption not only affects the employer contributions, but it affects the member contributions. Employer contributions, I mean, like you said, there is a generational question, but if if the employer over contributes, then they're going to get the benefit down the road. But members, when you set the rate, that's what they paid. They're not going to, if they have good experience down the road, it's not going to help them. So it's a tough call, and I wish I could tell you what to do, but it's
Yeah, sure. No, I mean, obviously, nobody's got a crystal ball, so you're trying to do the right thing. When those recommendations were made some years ago to, pull those investment expectations down, did that pan out? In other words, were the investment returns lower as was anticipated, or did they maintain more or less what they had been?
Once again, it's like Daniel talked about, it's time horizons. Yeah, if you go back when we originally pulled them down, yes, because you factor in the financial crisis in there, which kind of drove returns for years. Now, obviously, and before the financial crisis, we were showing lower expected returns. After the financial crisis, we were projecting, returns were going to normalize a little bit. But I would say, recently they've been higher. But once again, once they've been higher, now all your valuations on your stocks are higher. So our investment consultants, when they've come out that, Daniel was talking about, we've been lowering our, long-term forecasts, because we don't see the appreciation there. So we would be a little bit lower than what this number is, and we honestly wouldn't be that too far off. But I will say,
if I can interject, can we
side.
just stay focused on the agenda item, which is to go through the audit? I mean, Chris, I understand your position, but we can have that discussion with the next time we have a conversation with our actuarial.
Okay.
All right, with that, I'll hand it back to Nick.
All right. So the partner to the economic assumptions is the demographic assumptions. Those are things like, when people retire, how long they're going to live. So on that, we did kind of a twofold analysis. We kind of looked at. We did not replicate on the evaluation. We replicated all the numbers. On the assumptions, we just looked at Chiron's experience study and then applied our professional judgments. Hey, these were the results that they came up with. Were the recommendations reasonable? And we felt that was the case. We also did a comparative analysis with other California systems. Some of the stuff we expect to be right in line, and you can see like the life expectancies there. SDCERS is kind of right in the middle, but it's a really tightly bunched. So the bottom line is we felt everything was reasonable. We also looked at kind of the technical details that only an actuary can appreciate, and we felt that Chiron is using what we would consider best practice and consistent with what we recommend to our clients. I'm going to have one comment on the assumptions on the next page, which has to do with service retirement, so that's rates people retire. On that one, obviously you've got the new plans, the 2009 plan for the city, and you've got the Pepper plans. By the nature of this plan, since they're new, it's hard to, usually what we do is look in the past and project the future. Well, we don't have any retirement experience for the Pepper plans or the 2009 plan. So obviously we've had, for our California clients, we've had to, implement Pepper plans. And so similar to SDCERS, the Pepper plans have lower benefit levels than the original plans. So we made some adjustments. We projected lower retirement rates, which means later retirement, which makes sense. People have a certain standard of living they want to have, so they're going to try and get that in their retirement benefit. So with that as kind of backdrop, we thought the Pepper plans, the results were a little different than what we would have expected. In particular, we've got an example here of the Port General folks. This is like a career employee that the percentage on the side is the percentage of the final average salary. You can see under the classic plan for a career employee, so retiring at 55, they would have got about 75%. Under the new Pepper plan, the Pepper 2024 plan, it's less than 40%. So therefore, we would lower benefit levels. We would expect people to wait to retire. And you can see here, the average retirement range is actually less under the new assumptions. There is some relationship with the eligibilities, but we still would have expected a later retirement. So oh yeah, and I should mention that the city, on the city side, this is an example of city general members. City side, things went exactly what we expected, lower benefit levels, therefore people are expected to retire later. So we would just suggest some additional scrutiny with the next experience study on the Pepper retirement rates.
Quick question on that.
Yeah.
This audit was done based on closing 24 information. Is that correct?
Yes, I mean, we when we looked at the 2023 experience study, we said, hey, what were the recommendations then? And we did take, count that they were basing it on at that time. But yes, but we looked at in today's.
Been quite a change over the last few years due to the unwinding of Proposition B in terms of the number of active retirees that we now have into the plan. Is that considered in your audit here as well, or is that not a material issue from your standpoint at this point?
Well,
I mean,
it is in the respect of, obviously in the, the calculation of liabilities and stuff, we've reflected the new population. As far as the, like this, what I'm talking about on the assumptions, I mean, basically we've just got a new group that we need to reflect. So I don't think it's, I would say it's not materially affecting to get to cut to the chase.
Not in there.
Yeah.
Not in there, but you don't think it's a material impact?
Yeah, I mean, we think they're going to behave similar to the old group, except for the fact they're in different plans.
Yeah.
So,
Thank you.
so now getting to recommendation considerations, going to just break these down into three groups. First two are changes that would affect the calculations, but these would be minimal impacts. We're projecting less than 0.1%. So Chiron's planning to implement with the next, the 2025 valuation. So you're not even going to notice it. It's just going to be behind the scenes. But just noting that. There's two assumption ones, and obviously I talked about the retirement rates for the Pepper plans. Right now, not a huge impact, but this is actually one thing to your comment. As you get more people in the Pepper plans, it could have a bigger impact, those retirement rates. And the other thing we note that is those retirement rates, because the benefits are directly tied to that. The member contribution rates are tied to that. If these rates were changed, it could affect the member contribution rates. And the last two items, 4 and 6, are just disclosure items that we made some recommendations on, but have no impact on the numbers. So we get to two favorite words you hear from an actuary: in conclusion. So in conclusion, we found all the work to be reasonable, as I said, which is kind of our gold stand. The assumptions were reasonable, the calculations were reasonable. So with that, I will conclude, and we thank you for your time, and we're happy to take any more questions, and we appreciate the questions along the way.
All right. Well, thank you very, very much. This project was extremely important, to actually validate the governance of the plan. And also, when you do actuarial audits, we always find something in an audit. And it's good to catch those little things soon before they grow into large issues. With that, I was hoping that we could hear from Chiron just for a brief statement of do they agree with the findings, they don't agree, and just to hear from Alice Alsberg, our co-lead actuary from Chiron.
All right, let's see, is this microphone on? Yes, great. Thank you for having me. Thank you, Greg, and thank you to the SDCERS board for allowing me to come today and speak following the reporting from Milliman. They performed a very comprehensive audit. The questions, the pieces that they dug into through the liabilities, the member contributions, the assumptions, we certainly went back and forth on many fine-tuned details with Milliman questioning our work, how we performed some of the calculations, and in aggregate, everything came out reasonable. So we got a clean stamp of approval from the auditing firm. There was this summary page that had the 6 items of note. We were pleased to see that they found 9 terminated vested members who were being valued in one method versus another method, which would impact a very small population out of the tens of thousands of members. But it's good to find those 9 and adjust those members. Other pieces of the valuation, for example, the PEPRA retirement rates, we will certainly look at that with the upcoming experience study. And based on our current cycle, we'll actually be performing the experience study starting this spring, right after the conclusion of the 2025 actuarial valuation. So we'll get into full detail of assessing the economic assumptions again and the demographic assumptions, in which case we'll be looking at those PEPRA termination or PEPRA retirement rates. And there are many systems across California that do have the PEPRA tiers. The city plan does not have PEPRA members. It's the port and the airport that has the PEPRA members. So it's a much smaller population with significantly less experience from what's actually happening at this point. Given that the plans were implemented in 2013, we're still in the thick of the career of these active members. But this is something we will certainly look at, and we appreciate the feedback from Milliman pointing out some of the pieces that caught their attention that we will now address with our evaluation and our experience study.
Is there a scenario where Chiron would do a review of Milliman? Is this an industry where actuarial firms would verify each other?
Where we would verify their work of this SDCERS?
No, in other
for other clients, for other systems. Oh yeah, we certainly audit each other very frequently.
I see.
Yes.
And are there conflicts of interest elements here that we should be aware of, like joint ownership?
There are zero conflicts of interest in terms of joint ownership. In terms of all professional, in the actuarial profession, the actuarial standards of practice that we follow, the guidance that we follow, we maintain a very professional relationship and keep completely separate in terms of the communication. So there is no behind the scenes conflict of interest or even any conflict of interest, I believe.
Okay, any other questions or comments?
If I could just make one more comment. So it was great to have Chiron here to give you an oral representation of did they agree with the findings or not agree with the findings. They actually agree with all the findings, and I've asked Chiron to document that in a letter that I will stick in my file and hold them to it. So thank you all very much.
Thank you very much.
Thank you for your time and attention, and thanks for hiring us for this. It was a good project. Thanks to staff.
And thank you for
All right.
validating their work as well.
Yep.
Okay, I need a motion and a second.
And Madam President, it was moved by Paul Lodes. And if I could just get a second. Seconded by Mr. Chris Brewster. And Board members, please feel free to cast your votes.
Who's acting strangely?
And with all votes in, Madam President, this motion passes 12-0.
Okay, thank you, Rosie. So now we will move to business and operations item, board members' annual fiduciary training. So I'll turn it over to Johnny to introduce this item.
Good morning. Thank you, Lisa Marie. It's my pleasure to introduce to you Ashley Dunning. She is a partner at the Nossaman Law Firm and has served as SDCERS' fiduciary counsel for several years, first in the 2010s and then in more recent years. In addition to helping us, she serves as fiduciary counsel to the New York State Teachers Retirement System, CalPERS, the Public Employers Retirement System of Idaho, and serves as fiduciary litigation, governance, and special projects counsel to the majority of our county systems, as well as city systems of Fresno, San Francisco, San Diego, and Los Angeles. In her free time, she also serves as general counsel to Marin.
Johnny, I did have a couple of questions from some of the board members, and we're just curious, is this training required to be done annually?
It's required by this board.
Okay, so it's a board policy.
Yes.
Okay, got it. Thank you.
Collectively, she helps protect over $1 trillion in trust assets. Today, she's here to provide general fiduciary annual training, so I appreciate you flying down here this morning, Ashley.
Thank you very much, Johnny, and very nice to see all of you, members of the board. This is the annual training that the board, I think, is sort of a best practice to have annual training. I recognize that some of it will feel like a repeat, which is probably good for all of us. But I also try to refresh the hypotheticals and discussion points as much as I can to make it as interesting as possible. So with no further ado, this slide will look familiar except for the last bullet point, which is that we've added a conflict of interest refresher to this training, as that seemed like it might be something of interest. First of all, definitionally, you're all fiduciaries. You know that. This is describing why you're a fiduciary. You're managing other people's or administering a plan of other people's money. It's not your money, it's their money. And so you have very important duties that you need to comply with respect to how you administer the fund and invest the assets of the fund. Because of this responsibility that you have, as defined in the last slide, I've set forth in this bullet point how that duty works. And I've heard fiduciary duty discussed in various different forums in ways that I think sometimes are accurate and other times are inaccurate. So I really want to hone in on all aspects of what this means for you as fiduciaries at SDCERS, which is that all of the trustees here, as well as the executive officers, are fiduciaries. As a consequence of that role, you have these duties of care and loyalty, which are the paramount duties. We'll talk about some nuances within those for public plan fiduciaries in California next, but two components are care and loyalty. To whom do you owe those duties? It's to the members and beneficiaries of SDCERS and qualified beneficiaries. So it's not to everybody, it's just to those individuals. It's not to the plan sponsors. It's to the members and beneficiaries. Is it to every aspect of their lives? No, of course not. It's only with respect to the retirement and related benefits that SDCERS owes to them. And this comes up a lot when people are talking about, well, there are other things that matter to your members. Of course there are. But what is your responsibility relates to the preservation and security of the assets used to timely pay their promised SDCERS benefits. So those are the benefits due to them by the retirement system. So it's both broad and narrow. I mentioned that you have other duties that we will talk about. These are duties that are outlined in the California Constitution. Of course, loyalty and care we talked about, but the other ones are specifically stated in Article 16, Section 17 of the California Constitution, so we'll walk through those. This is to reiterate and provide citations for the duty of loyalty, which is also known as the exclusive benefit and primary duty rule. So you can use these trust assets for the exclusive benefit of the members and beneficiaries, not for some other purpose. And your primary responsibility, which has precedence over all other duties, is to those individuals. There are constitutional directives around minimizing employer contributions and defraying reasonable expenses of administering the system, but those are secondary to the primary duty to members and beneficiaries to make sure that they timely get their benefits. And therefore, putting that duty to the members and beneficiaries behind other interests that others may have is essentially a breach of fiduciary duty. This is a conflict of interest rule at its core. And therefore, one is not to put the duty, is not to put the interests of the city or the port or the airport or of a particular union or a particular retiree group or some other interest group ahead of those interests of your members and beneficiaries and their vested SDCERS benefits. I didn't say at the outset, but I'm happy to take questions as we go through this. I'm speaking quickly because I know that you would like to get through this, but I do appreciate questions. This takes us to our first hypothetical on the duty of loyalty. So we have Sally. I've tried to protect the innocent and not use any names of anybody in the room. I'm sorry if anybody behind me has the name Sally, but I think no one in front of me has that name. So Sally is a member of the Board of Administration, and Sally is an appointee, appointed by the city. Sally has other responsibilities in her life, other things that she does, and one of those is that she serves on a local nonprofit board that receives funds from the city for its efforts to keep the public beaches in San Diego clean. A city executive requests a meeting with Sally to discuss the city's upcoming funding priorities as they pertain to both SDCERS and the nonprofit's work. Sally is a bit concerned about the scope of this meeting that has been proposed, and she did go to the meeting, and she shared her concerns with another SDCERS board member as well as with your CEO. That same city executive who had met with the appointed board member presents to the SDCERS board at a subsequent meeting regarding policy decisions that are coming before SDCERS with respect to the annual valuation. So assumed rate of return, perhaps, other topics, perhaps, that may impact contributions due from the city. So in this context, in this hypothetical, what are fiduciarily appropriate considerations for Sally and other board members and the CEO with respect to the city's communications with that board member? Any comments?
Well, I think Sally shouldn't attend the meeting.
She shouldn't have attended the meeting with the city. That certainly makes things a bit easier.
Engaging in multiple communication with multiple members and the city, starting to risk serial meetings outside of a scheduled meeting.
Well, possibly. I mean, the issue about serial meetings relates to communications with these board members or your CEO potentially with board members creating a serial meeting. Having a meeting with a city representatives wouldn't necessarily lead to that. But the issue is Sally getting pressure from the city to make decisions in her trustee role that are not congruous with her fiduciary responsibilities? And that can become a risk and a problem and a perception, an issue of both perception and reality if that's what's happening. Yeah, go ahead.
Question. That's bound to happen in the course. That's natural reaction from people. The question is, what does Sally do about it?
Which aspect of it is bound to happen?
Well, the meeting and the meeting between the city officials and.
There will be
board members.
meetings from
There
time to
will be.
time.
Yeah, yeah.
Right. And so the question is,
That in itself is not the problem.
well, is the trustee trained enough, reinforced enough, supported enough? Does that trustee understand the responsibilities as they go into that meeting, if they take the meeting in the first place? That's really the question, and that also goes to an earlier question about why do we have annual training? Because one needs the reinforcements, the understanding, the recognition for everyone. It may be that the city executive doesn't necessarily understand the relationships. Not to impugn anyone, it's just a reality. It's not necessarily their world. And so it's important and it's incumbent upon the trustees to know what their role is and responsibilities are.
And also, we don't know whether Sally has made prior disclosure of this additional activity where she's involved. Because if...
That's right. It should be, well, we'll talk about conflicts of interest and what needs to be on your Form 700.
Right.
If this were a compensated board position, it would need to be on the Form 700. It's
Right.
if not a compensated position for a nonprofit, it doesn't necessarily need to be, and therefore it may or may not be.
Right, and that is, if she's indeed following all the rules under requirements of Form 700, typically nonprofit boards are not compensated.
If not compensated, right.
But then this is an awareness issue, I guess, to put it in your vernacular, that if indeed the nonprofit is getting money from the city, there could indeed be an appearance of conflict.
An appearance or a reality.
Right.
Right, and so in the sense that if this individual is feeling like the funding for their nonprofit is potentially going to be compromised as a result of their decisions on the SDCERS board, that's a serious problem from a fiduciary perspective.
Ashley,
Yeah.
I'm sorry. Is this a one-way street? If we take a look at the city, do they have fiduciary responsibilities that corroborate the fiduciary responsibilities we have here?
They are not co-fiduciaries with you, right? So they are not fiduciaries to your members and beneficiaries. They could be
Are they fiduciaries?
potentially,
Yeah.
excuse me.
Are they fiduciaries to their employees?
No, it's interesting. It's a different, the employees are fiduciaries to their employer.
Okay.
Yeah, so no, they do not have the fiduciary relationship that you have to your members and beneficiaries.
So in your particular case, this is strictly on us?
It's strictly on, so it depends how far you go down this. There are some aiding and abetting liabilities that can occur in connection with, say, conflicts of interest. And we'll talk about that later. But you are the fiduciaries. You all have co-fiduciary liability and co-fiduciary responsibility. But the city is not a fiduciary to their members and beneficiaries. Yes.
Would I be right in assuming that if the executive had wanted Sally to come in and speak to her strictly about her board role on the nonprofit, like the beach cleanup, that would be appropriate to do? But it's the fact that it's the combination of the two that kind of makes it, hey, that it's the fact that they're connecting those two that makes it really problematic.
That's the clearest problem here. Sometimes things can happen that are not as explicit, and so one needs to be aware of that. I think that's actually a really important observation, that each of you as trustees of the SDCERS board is perceived in a particular way. And so if you are attending events, if you are speaking to people, you have to be abundantly clear that you're not speaking in your role as a trustee if that's the case. Whether it's in a union context or a city context or out at some conference. Really, really important. Or if you are, then you make that clear as well. If you're authorized to be somewhere on behalf of SDCERS, you can only wear that one hat when you're wearing an SDCERS hat.
Yeah, and I think to add to what Christiana is saying, in a hypothetical, and we've certainly had this before, where the city has something pending before us, right? We would like to change the UAL, whatever it may be, and coincidentally, Sally gets a call from whomever at the city saying, hey, we're thinking about increasing funding your nonprofit, I suppose, right? You have to take that into account.
Well, that's exactly right. So that would be the more subtle approach, but equally problematic if what's really going on is there's a suggestion that one is tied to the other.
But in general, the plan sponsor shouldn't be lobbying individual board members.
100%.
That's why I think it's best in her interest, she can meet with them on the nonprofit, but they can't talk about SDCERS and to defer them to the CEO.
That's what I would like to believe is happening.
That was my prior point. There's nothing stopping them from lobbying, but there's, we're
And
prevented
that's why
from
we need to tell
accepting
them
the
we're not
lobbying.
going to talk to them about it.
Correct, yeah.
Right. And that's why it's very important that you delegate to your CEO, for example, the responsibility of having communications that person has the responsibility to manage and not have individual board members be the target of the pressure. The fiduciary duty of care is also set forth in the California Constitution as well as in the Muni Code. And I've included the specific language here. We've talked about it in either presentations. This is not a duty of care to act as a layperson with no knowledge. It's actually a duty to act with care as somebody who does have knowledge in the area of expertise required for the particular topic. And that's a big responsibility given the number of areas of expertise that matter for SDCERS. It's, you have your disability retirement adjudications, so you need to have some level of understanding so that you can make prudent decisions on those topics. Legal matters come before you. You're not the lawyer for the system. Mr. Tran is the lawyer for the system, but you have to know enough so that you can be a prudent fiduciary in that context as well. Plan administration, investments, the list goes on, actuarial. And typically the analysis is, were you using prudent processes in your consideration of matters? But in my experience, if the ultimate decision does not appear to have been prudent, both substantively and from a process perspective, you may well be challenged on it. Because there are so many areas of expertise that are required in order to be prudent in this arena, it is also considered a mark of prudence to consult with experts. The implicit corollary to that is that if your experts are advising a particular course of action and you reject that, then the bases, the reason for rejecting it should be grounded in the expertise that's called for, not simply because you don't want to, or because you're using expertise from a different arena. So a good example, since you just had your actuarial audit, is if you're looking at actuarial assumptions, you should be consulting with actuaries on that. Certainly, they're looking at capital market expectations. They're looking at what investment professionals are saying. But as the actuaries, I'm sure, will tell you, their assumptions are based on very different timelines and trajectories than your investment professionals. I love the comment about it depends in the last presentation about it depends upon when history starts. I love that. I wrote that down. It depends when history starts. It also depends when it ends for purposes of your assumptions. So if your assumptions are supposed to be based on a 30-year trajectory and you're being given an expectation for the next 5 years, that's of limited value.
What happens in a situation where the expert opinion is incomplete and it turns out to be, you know, the board member makes a decision based on this incomplete set of or incomplete advice and ends up being putting the board member in a situation? Is it a defense for the board member that I followed the advice by the expert? Is that considered to be a viable defense?
So there are a couple of ways of approaching that. First of all, the fiduciary does need to ask questions and probe, and if it appears on its face as though it's incomplete, it's on the fiduciary to push, to ask for completion. In terms of potential liability of the fiduciary, typically relying on advice of experts is very useful to establishing that you were complying with your fiduciary responsibility. Is that the end of the story? No, not necessarily. As I mentioned before, courts will look at, they will probe themselves. There are a couple of cases, Howard versus Shea, the Tibble case that went to the U.S. Supreme Court in an ERISA context, where the court concluded that the decisions that the fiduciaries made based on advice of their experts were just patently unreasonable. That was a context where a board was investing in a retail product rather than a product available for institutional investors, and were paying more for the same product that they would have been able to receive for less as institutional investors. The court said that's not reasonable. And so the plan lost that case. Was the individual found liable for something? No. But it was not a good situation.
Yeah, this is a question I was going to ask at the end, but I'm on a 501c3 foundation board, and the ultimate punishment for breach of fiduciary duty is to lose your 501c3 status. In a case like in a public plan, if a board breaches its fiduciary duties, what's the ultimate conclusion?
Well, the ultimate penalty, of course, also would be to lose your tax qualified status. That would be an ultimate extreme. Something that is more frequently considered is whether there would be a court action with a finding that the plan and the fiduciaries breached their fiduciary responsibilities. When we're talking about liability in the public, in the governmental space, it's a little bit challenging to answer that question completely without really going into the details, because you're given a lot of protection under the law, immunities, discretionary protections, et cetera. But as your fiduciary counsel, I'm not advising you to lean into those right now. What we're saying is let's work on compliance. And then, if there are ways to manage potential risks and liabilities, you do that as well, if that makes sense. But I appreciate the question. This slide goes into the prudent expert with experience dealing with similar enterprise, mouthful, a little bit more. That's the standard that applies. Noting that expertise on which you rely resides both in your staff and your outside consultants, and it's important to recognize that and to draw on that expertise. And then you develop your own capabilities in these areas so that you can provide the type of oversight and monitoring that is needed. And I've included some ways in which you do that on this slide. Here's our second hypothetical. Board member Max is personal friends with an ailing active member of the retirement system who's applied for disability retirement. Max has spoken with a member about the application. The competent medical evidence establishes that the member is not permanently incapacitated under the applicable legal standards, and retirement system staff therefore recommends that the board deny the application. The applicant attends a board meeting at which the application is considered and speaks to the board about the application, urging the board to grant it. In this context, what are fiduciarily appropriate considerations for all board members, and in particular Max, with respect to this topic?
Well, I would just say the personal friendship is enough to make you recuse. I don't think there's a problem with a board member telling people how to apply or giving them the basic information, but that's different from the personal relationship, I think.
So yes, and think about yourself in a role as similar to a judge. You're the adjudicator, and so just as judges need to not communicate about cases with individuals who are before them, so too you should not be. That doesn't mean that you don't say there's an application process to somebody you know in your department whom you might work with or somebody whom you know socially. Yes, there's a process by which one applies. Go to the website, you know, the numbers on there for where you call or how you do this, but you don't get into the role of advisor, and certainly should not be similar to the meeting with the city. Do you take a meeting to talk about the facts behind the potential application? No, of course not, because then you are putting yourself into a position where you most definitely need to recuse. If you are a personal friend with the individual, the question becomes a little bit more nuanced, which is, can you be impartial? Are you too biased in favor of the person? Or maybe that you have a bad relationship with somebody. Are you prejudiced against them such that you can't be impartial? You need to recuse.
But what about the rest of the board in your question? Are there any issues for the people who've never met Max before here?
Typically, disclosure and recusal is sufficient to allow the board to go forward with its proper decision-making. The next duties that we'll walk through, I don't have hypotheticals for. We can walk through them pretty quickly. This first one is just a reminder that you have a mandatory obligation to diversify investments of the plan unless it's not prudent, clearly not prudent to do so. And diversification is considered based on the whole plan portfolio. There are some times divestment mandates that one will see, typically under the California, in California, those are directed at the state plans and are not that provision in the Constitution that allows the legislature to mandate divestment under certain circumstances is not a power that is granted to, say, a city council or a board of supervisors. It's granted to the legislature, and even the grant to the legislature is tempered by the fiduciary savings clause, which basically means the legislature can say, thou shalt, and yet it has to also say, provided it's consistent with your fiduciary responsibilities to do so. Another duty that is identified, or another responsibility and power that is provided under the California Constitution relates to your actuarial services. This is a theme from today, which is good, given the last presentation. It is within the power, the plenary authority and responsibility of this board to hire actuary and to make determinations in consultation with your actuary about what they opine on, which relates to contributions, which results in whatever the contribution rates are. This was very important when it was put into the Constitution because it was in Proposition 162 in reaction to an effort by the state to take over the actuarial function of CalPERS, to have the state decide how much it owed to the retirement system, which of course is not the way one properly funds an actuarially a defined benefit plan. There are plans around the country where you have legislatures that just decide how much they're going to pay by statute. That is not ideal. And as I say, in other contexts outside of California, I think California is really a sort of gold standard in terms of this aspect of the funding of plans, that it's within your power, and thus it's your responsibility to manage it prudently. I cited a case here that came down a few years ago involving one of the county plans, and this was a claim of breach of fiduciary duty by the board with respect to how they handled certain actuarial aspects of the plan. The board ended up prevailing in that litigation, but it did go to court. It did go to the Court of Appeal twice, and so it ended up having to go to trial to get an ultimate resolution that the board had not breached its fiduciary responsibilities when taking certain actions that resulted in decreasing employer contributions. There's a duty to defray administrative expenses of administering the system. And I cited this Tibble case I mentioned before, which discusses the cost-conscious management of a fund as being part of the responsibility of prudence. As with the other discussions, this duty doesn't mandate a particular specific course of action, but you do need to have cost-conscious management of the plan in mind as you administer it. And then finally, there's this duty to administer the plan in accordance with the law, which seems fundamental, but it comes up more than one would think, where it just doesn't seem right, for example, that there be a certain result under a particular set of facts. And yet, if that's what your plan provides, then that's what you do. This is my summary slide, which you've seen before, but I try to sort of put it all together into one slide for you so that you have a place to go if you're looking at that for that standard, with a specific note that what you may not do is be arbitrary or capricious in your decision making. And so if anyone is saying what the board's about to do is arbitrary, that's a moment to pause and work it through and come hopefully to a place where at least the majority, if not all of you, can reasonably say what we're doing is not arbitrary and here's why. All right, so we will now move quickly through this conflict of interest discussion. There are two different components to the way that, or there are two different sets of statutes in California that govern conflicts of interest. And then there's common law, which is case law that develops around the application of these statutes, as well as general common law principles. The idea underlying conflict of interest law is that public officials, which is what you all are, because of your role on this board, are not to be acting in your own personal financial interest. You're to be acting in the interest of those whom you serve. The two sets of laws are the Political Reform Act and 1090. The Political Reform Act is the law, the set of statutes that govern everything that you do, all decisions that you make. The 1090 governs decisions that you make that implicate a contract. That's the primary difference in terms of whether you're looking at one versus the other. And both of them have multi-step analyses that I will not spend a lot of time on. This is something that I train on in the 2-hour ethics for public officials course that you're required to have every 2 years. And the discussion of conflicts takes an hour. This will not be an hour. This will be more like 5 minutes. But I just want you to be aware of these steps so that it's, again, a refresher. The first two questions are easy because you're a public official, and are you involved in the decision? It's very broadly defined. So if you have not recused yourself from the beginning, you're considered involved. The third question is whether you have a financial interest in it. And if you look at your Form 700, that's a good place to start. It won't necessarily identify every financial interest that could potentially be a question because, for example, your own home that you live in that you don't declare as a business or for business purposes is not on your Form 700, but that could create a financial interest under this analysis. Fourth question, is it reasonably foreseeable that SDCERS' decision will have a financial effect on your financial interest? So let's use a concrete example in order to illustrate this point. And I'm going to pick on BlackRock just because it's easy for me to say. So BlackRock is before the board and wants to have an additional allocation. Do they have a financial interest in that? Well, yes, of course. if one of you has identified BlackRock as a company in which you own stock, so you own more than $2,000, you have a financial interest in that. So the answer is yes to both 3 and 4 in that context.
So to be clear, the de minimis threshold is at $2,000.
It is $500 under other circumstances, $2,000 as to investment interests. Well, under $2,000. If you own $2,000 or more,
$1,990.
you have a financial interest in them, and they have a financial interest in SDCERS because they're coming before you wanting an additional allocation. Is the effect on your own financial interest material? Yeah.
Just saying that for a second. We use, excuse me, we use a series of outside consultants to manage these funds for us. So it's highly likely that some of those funds have corroborating investments that we also own.
Right.
I assume that because of that relationship, there's a veil that can't be pierced along that line.
As long as you're not influencing the decision-making with respect to those portfolio-level investments, then you wouldn't, right? And you're, say, in a limited partnership circumstance, you wouldn't be inherently.
Does that include us approving the investment?
You improve, so if you're...
What they want to invest in, the board approves it.
I'm sorry, say that again?
They say Aon advises us on a package of investments, which possibly includes a component that we own. The board then approves it. Does that mean we're in conflict?
If you own one of the investments that they're improving, if you own if you have $2,000 in stock in one of the ones that they've approved, I mean, that they're recommending that you authorize, then you have answered yes to the first 4 questions. Yes. So you're a yes. You do have a conflict until we get to these other questions.
Must be missing something there. That sounds unworkable. They're dealing with thousands of investments in their portfolios.
Okay, so maybe I understood your question correctly the first time, not the second time. So if you're talking about an investment where that manager will then make investments on your behalf, you don't go beyond the first.
That's what I mean. Okay. Yeah.
Right. You don't have to worry about what they're investing in.
Right. There's a veil in there that
That's
can't
right.
be pierced. Okay.
That's right.
Yeah.
Because that portfolio company isn't before the board. It's
Right.
just BlackRock that's before the board.
Yeah.
Right.
That's a case for why you want to use consultants in this regard.
Well, consultants and managers and VNLPs and not do direct trading.
Yeah.
Right. I mean, if you're doing direct trading, then there'd be another type of compliance mechanism and shields that would need to be put into place.
Can I play that out for a bit?
Yep.
So about a year or so ago, we had a number of managers here pitching for, I forget what was, let's just call it an infrastructure allocation. Apollo, BlackRock, I forget who else. And many of these are massive financial institutions with lots of different investments, lots of different portfolios.
Right.
And so playing devil's advocate here, so let's say Johnny, well, no, another Johnny who is on the board, has $5,000 in one of Apollo's other funds. And Johnny is a voting member on the board and approves Apollo as for this new mandate. Like, well, how does that work?
That's exactly what I'm talking about.
So Johnny should have recused himself.
And so you get to this number 5. There's an exclusion for small shareholders, which you would think applies, unless, which is what I bolded, unless certain monetary thresholds are met. Well, if what you're talking about is, I'm going to change your hypothetical, is AT&T. You're deciding a new telephone system for the retirement system, and the value of that contract is $50,000 to AT&T. And Johnny owns AT&T stock. That falls within the small shareholder exception. But if you're talking about an allocation of $100 million to Apollo, and he owns $5,000 in Apollo, that small shareholder exception doesn't apply. Because the value of that to Apollo is over $1 million by a lot.
So that would only, to play that out, if Johnny parks his money with a local registered investment advisor who's making investment decisions for him, and they have money in Apollo. So it's not technically a blind pool because he can see it. He doesn't have a decision over it, but he sees that he is benefiting from, he sees that he has an investment in Apollo. And then this registered investment advisor continues to put more money into it. And then Apollo comes up here for a vote. Johnny should have recused himself as well.
That's right, unless it's a blind trust.
And just to be super clear, a blind trust is absolutely no transparency. You cannot see it until the end of your term as a politician or whatever the term is. And, okay.
That's right.
And you have no, and in a blind trust, you have no discretion. Even though you have a registered investment advisor, you can call up that person and say to her or him, I want you to buy X or I want you to sell Y. That can happen with any RIA. Just also to be clear, under the BlackRock example, where they come in and we're going to give them $50 million, you can own common stock in BlackRock under one scenario, or you could be an investor in a different BlackRock fund, because BlackRock is a good example because they're so large and they're publicly traded.
So I'm going to give you this FPPC advice letter here, which I asked for personally, and it involved this exact example, which is if you own $2,000 or more in BlackRock,
Common stock,
do you have to recuse if BlackRock is coming forward to ask for being considered for an allocation? And the FPPC basically said, you won't have a problem if you sell your stock or you put it in a blind trust. That's what they said. And they did not mention small shareholder exception, any other exceptions. And the FPPC has brought enforcement actions against people that have been very, very public for these types of issues. So I would not rely upon de minimis or it doesn't make sense. I would take them at their word, which is that these types of circumstances where you have a financial interest as defined by California law in something that SDCERS is investing in at these high values. So we're talking, putting 50 million or 100 million into something in which you are deemed to have a personal financial interest. That may create a disclosure and recusal responsibility.
But my question was on the distinction between owning common stock and alternatively being an investor in a fund managed by BlackRock.
Yeah.
Mm-hmm.
The common stock, I think, is pretty clear, and I think all of us take that very, very seriously.
Yeah.
And because it's
right.
A fund issue.
But it's because you have these enormous supermarkets,
right?
These financial institutions that, like a BlackRock, and I use BlackRock rather than a Vanguard or a Fidelity because Vanguard and Fidelity are privately owned.
Mm-hmm.
So the question is, you don't own BlackRock stock, but you invest in a BlackRock bond fund, and we are considering and have hired BlackRock to manage bond monies for us. Should we either recuse ourselves or sell our bond fund? Or what if we own a small cap equity fund and BlackRock is up for a bond mandate? We want to do the right thing here.
Yeah.
Right.
What I would say is that this is intended to raise your level of awareness, which it has and does, and that when these circumstances come up, you should refer them to your general counsel so that you can get specific advice. And as your general counsel will also tell you, the legal office, as well as fiduciary counsel, won't advise you individually on matters that pertain to your individual liability, other than sort of general parameters. Here are the rules. This is what we think. because he's not the lawyer for each person individually. And these are very complicated circumstances, or fact, these are complicated analyses that need to be done carefully and in advance and not on the fly in a board meeting. So I'm not trying to duck and dodge too much, but that's the idea.
Why am I feeling uncomfortable about this?
Well, okay.
It seems like it's you could drive a Mack truck through this thing.
Well, but
Basically, you put everything in mutual funds.
But I think in the big picture, actually, there's a reasonableness aspect to this, and the reasonableness aspect is a decision that we make here likely to favorably impact an investment you have? That's really the intent of the whole thing. So, and I'm just going to give an example. So let's say a board member here owns $50,000 worth of Microsoft, and SDCERS has just recently decided to contract with Microsoft to provide computer services or whatever. This is going to have zero impact on Microsoft from Microsoft's stock value and so forth. And I think that the main point of all this, and I understand there are specific thresholds and so on, is don't make a decision where you have a reasonable expectation that it's going to financially benefit you personally.
So I give you a big caveat on that, which is that the rules that I'm going through are really specific in terms of the monetary thresholds, and they do not correlate with everyone's view of reasonableness. So there may be somebody where it doesn't matter to them at all financially how this plays out with respect to what SDCERS is doing, and yet they still pass those monetary thresholds where the FPPC would say this matters.
Okay.
Okay, so that's what I'm trying to impart to you, that one shouldn't just rely on one's own sense of what matters. There are very specific rules with lower thresholds than you would think that can create conflicts of interest that require disclosure and recusal.
Well, I think Cliff's advice is good then. Sorry.
Yeah.
In some cases, recusal isn't enough, correct? So it makes sense that the board's advisory attorney can advise necessarily on your personal situation, you still have to mention it because it could color the whole board, or is that slightly different?
Okay, so there are two different aspects of that. One is that under the FPPC, what's required is disclosure and recusal. So there have been circumstances where people have recused from a decision by walking out of the room, but they didn't do a proper sufficient disclosure that was reflected in the minutes, and so it came back to bite them. There's another aspect of this, which is if you get into 1090 land, which is where we go next, then disclosure and recusal may not work. So we'll get there right now.
Can I clarify on that? So
Yeah.
recusal is both discussion and vote?
Not recusal has to be preceded by disclosure.
No. So there are scenarios where recusal just means not voting. They can be a part of the discussion, but when the vote comes, they leave.
Right.
Here you're saying it's both discussion and vote.
Correct.
Okay.
It's from the very beginning. That's why I said the second question is, did you participate through communications or any other, even talking behind the scenes, trying to influence a
Yeah,
decision?
brings up the question of when did history start? But
Right.
So the fact that I have a 401 or a 403B and I have only certain sort of selections in there, some of which are BlackRock, like that itself would be sufficient.
If you own the stock, that is, even if it's in a 401k or whatever, or 403b, ownership of individual stock, everything that has to be reported in your Form 700.
Yeah, okay.
On that point, yeah.
What happens if the 401k is being managed by a third-party investor?
Doesn't matter. It doesn't matter if you have individual stocks in there or bonds. I know, it's something else.
Well, I hope Microsoft's not going to be hurt by my sale tomorrow.
So the sixth question here is something that I include because it's part of the analysis, and yet it was preceded by all of these warnings. So there is this provision, is the effect on the financial interest too insignificant? But then I know this is an objective test, not subjective. And the FPPC advice letters that we've gotten and recent enforcement decisions do not rely upon this disqualification analysis. So if you follow what's going on with the FPPC at all and you see what their enforcement actions are, including around investments, you will see that there have been enforcement actions against people in the public plan arena in California that involve these types of issues. Seventh question, does the economic effect apply to the public generally? And then, is participation legally required? That's very rare in a multi-member board circumstance that participation would be required. So this is what happens if you have a circumstance where you've gotten to the end of this analysis, you've determined in consultation with either your personal lawyer or with system counsel that you need to disclose and recuse. This is how you do it. Same rules for employees. And what happens if you get this wrong and you go ahead and participate? So it is a crime. And the local prosecutor can bring a misdemeanor, a charge for a misdemeanor, precludes public office for 4 years, fines are up to $500 per occurrence, and decisions may be voided. So the second statute that governs conflicts of interest in California is Government Code Section 1090, and as I mentioned earlier, that applies where there's a contract involved. There are many aspects to 1090 that are of note, one of which is that board members are presumed to be interested in all contracts entered into within the board's jurisdiction. So unless you fall within a remote or non-interest exception that allows you to go forward, allows the organization to go forward with the contract, the organization simply cannot go forward with the contract, even if you recuse. There's also a provision that prohibits an individual from aiding or abetting in the violation of 1090. So 1090, as you probably may know, was the subject of the prosecution of SDCERS trustees in the case that led to the California Supreme Court's Lexon decision. And the aiding and abetting provision was added to the California statute following that decision. This is also a multi-step analysis where the first part of it should look pretty familiar. Are you a public official or employee? Yes, if you're on the board or are an executive. Is there a contract? Note that contract in this context is really broadly defined. It's not just a single contract. As in the Lexon scenario, the allegation was that there were multiple contracts that were linked to one another, MOUs, board funding decisions, et cetera, that the argument was there was a quid pro quo, according to the district attorney. Were you involved in making of the contract? Again, that is not just voting, that's developing, negotiating, modifying, et cetera, influencing behind the scenes. Do you have a financial interest? It's positive or negative. It could be a really bad deal for you, but it still is a financial interest. And this is where we get to whether an exception applies. Non-interest or remote interest are the two types. In the Lexon litigation that I mentioned, the Supreme Court ultimately concluded that the decisions that were made as to all but one of the trustees were decisions that were provided to the public generally served by the organization. So the fact that there were active members on the board who received the same benefit and retirees who received the same benefits as those implicated by the decision didn't create a prohibited conflict of interest because it was the same in all circumstances except for one, where one of the benefits was a union president benefit that one trustee and two others received, and that wasn't general enough. Rule of necessity is only for essential services. Again, it would only apply under very rare circumstances. I could imagine it applying in a circumstance where, for example, you couldn't pay retirement benefits because of a circumstance relating to your software or something, or, you know, I could imagine circumstances where that could arise under 1090 more likely than Political Reform Act. And as I mentioned, it's a violation to aid or abet.
Ashley, just,
Yeah. Sorry.
no, go ahead, Michelle, I'll wait.
Ashley, how does this work when we have thresholds for contracting that the CEO is able to engage in versus the board, and we may get notified later that we engage with a company that we might have a financial interest with?
That's a question I've actually asked myself as well. I wonder under delegation models how that works. I don't have an answer for you, unfortunately. I think that you're certainly better off under a delegation model from a 1090 perspective, but I just don't know how that would play out.
You're lucky.
I'm sorry. I wish I had a better answer for you. It just hasn't been tested that I know of.
I do have a follow-up question, Greg. Do you provide the board an annual list of the contracts that you engage in, just on an information basis, so we can see?
We do, through our legal office, we do provide a list of contracts, the high-value contracts. So we do that annually.
So we can see if it's...
Yeah, and those high-value, those do come before the board.
Okay.
My spending authority is $50,000 or less.
Mm-hmm.
So I don't know if that... I know that would impact the prior set of rules, but I don't know if it impacts these.
Because I didn't hear a monetary threshold for contracting where we would.
So I was trying to keep this shorter, so it doesn't have all of the specifics. There are much higher monetary thresholds with respect to investments for 1090, much higher. And so you basically have to own 3% of the company or something. I mean, it's just, so it falls within what I think was being alluded to as more reasonable for purposes of 1090. Typically, I wouldn't worry about it in that context, unless, but if you're just a passive shareholder.
So Ashley, my question was on the Lexon case. So Kathy Lexon was a member of this board. The board made decisions that would ultimately enhance retirement benefits, as I recall. She would ultimately become a retiree, so would benefit by those changes. And ultimately, the Supreme Court, in general, ruled that that was okay. Right.
Ruled that the public services generally provided exception, which is a non-interest, it's considered a non-interest under 1090, applied to that aspect of the case.
Okay.
So because Ms. Lexon was receiving exactly the same benefits, the same formula, or not the same formula as every other general member, that it was not considered a conflict under 1090.
I will say that she did have to go through a process where the district attorney went after her, and she had to go all the way to the Supreme Court to get that ruling. But
and she had to pay a lot of legal fees.
It was very painful for anyone close to it, I'm sure.
But you mentioned that some law changed since Lexon that impacted that. And what was the change?
The change was to add aiding and abetting liability, which means, for example, hypothetically speaking, were there somebody who was not did not have a financial interest, say an appointed member, did not have a financial interest in the decision.
Right. So wouldn't get the benefits, the enhanced benefits.
But they were aiding and abetting in the violation of 1090. They could also be prosecuted. Yeah.
Huh. Thanks.
Can I have a 30-second comment real quick?
Of course.
Thank you. I really appreciate your concern, and I know some of you are concerned. We take this very seriously, and part of that is this training today. Before any of you vote on any items, our team vets what is at issue, reviews what Form 700, what information we have from you on your financial interests. And if there's a concern, we work with Ashley. Ashley has an expert partner in this that we've received great advice to further refine our understanding of this, and then we work with you to help you make an informed decision of whether you need to recuse or not. This is ultimately a personal liability issue. So again, I continue to support you contacting us and not letting us passively handle this, because we're doing our best, but we don't know everything. So just rest assured that we're on this as best we can, and we appreciate your input and your concern for this as well. Thank you.
Oh, that's a great comment, and I have seen that firsthand, that there is a lot of proactive effort on the part of your staff to address these issues, but you are the ones who are going to know best what your financial interests are. Form 700s are interesting because they're inherently retroactive or retrospective. They apply only to the prior calendar year, so there may have been some change in your portfolio this year that no one would know about until you do your form for this year, next year.
Real quick,
Of course.
our insurance premiums that we pay every year, do they cover all those attorney's fees and things? What do they cover? Just curious, that insurance.
Well, we have insurance. We have a lot of different insurance, but I think these violations would be personal violations.
But we pay an individually out of our own pocket every year for board member insurance. So what does...
For concerning a breach of fiduciary insurance. So, I'm sorry, a breach of fiduciary duty. And
that's what we're talking about here, aren't we?
Not necessarily.
No.
We're also talking about a violation of 1090
okay.
and different laws itself.
So we're uninsured for that.
Basically.
So why are we serving on the board?
Right.
Why would we do this?
Well, SDCERS cannot buy insurance for you personally in your personal capacity and with your personal liabilities.
Well, no, and if there were serious wrongdoing by a particular board member, you wouldn't expect the trust fund to be paying for that. If there were, right, if there were criminal.
Separate insurance that we pay for.
So what you pay for, I believe what you're referring to is the non-recourse rider that basically means the carrier can't go after individuals who are alleged to have been in breach of their fiduciary responsibilities. Yeah, but that doesn't protect you from a criminal conflict of interest prosecution, for example, or from an FPPC enforcement action. And this 1090 is a felony. So it's prosecuted as a felony. It can result in imprisonment, permanent disqualification from public office, and disgorgement of all benefits received under the illegal contract, which is why I say if counsel is telling you there may be a 1090 conflict, you need to really listen. I mean, I've personally been very surprised at how much pushback sometimes there is on these issues when the consequences are so dire if you get this wrong. You really need to sit up and pay attention. Any more questions?
Yes, I have two questions, and I hope they're somewhat simple. You talked about our duty of care and loyalty to members with respect to benefits due them. Do we have the discretion to decide not to offer a benefit outlined in the plan due to concerns about the cost to the plan sponsor?
It depends on what the parameters are for the provision of that benefit. If that is a benefit that is in the plan that's a vested benefit that has to be applied, has to be paid, well, that would be one set of circumstances. If it is a benefit that can only be provided if it's done in a particular way, and I'll use a sort of a buzzword, which is cost neutral, then the question would be where the discretion lies. Does it lie with the grantor of the benefit, or does it lie with the administrator of the benefit? So that analysis would have to be done. If it's a completely discretionary benefit, then it doesn't fall into the arena of must be provided under the plan.
So to be more specific, if the plan says members shall have the right to do the following, may we elect in our discretion not to give them that right?
I think rather than giving specific advice on a particular topic, I should probably refrain from answering that. But what I'd say is you have to be sort of reasonable in your consideration of the various factors that matter
Okay.
on that question.
And my second question is, this is a hypothetical.
I'm sure it is.
If an appointing authority for a board such as ours will not appoint someone without requiring them as a part of the appointment to sign a resignation letter as a requirement of the appointment, that the appointing authority has the discretion to exercise in their discretion, does that create a conflict of fiduciary duties and just generally a conflict of interest between the independence of the board and the appointing authority plan sponsor?
That type of requirement would not be appropriate under California law.
Thank you.
Are there any other questions for Ashley? Well, thank you, Ashley. Clearly, we need this training every year.
That's right.
Oh, good. I'm glad I didn't waste your time. Well, thank you so much
Johnny,
for
as
having
well.
me. I appreciate it.
Thank you. So I think why don't we have like a 7-minute break?
7.
Yes.
Not 6, not 8. Hey,
Thank you.
take a quick moment of your time. You were asking the actuaries about
They discovered those X's.
Yep.
But the memos where she's planning on using, so I'll leave it alone.
Why is it not letting me? Oh, there it is. I'll go to that. And then
Oh, perfect, perfect. Okay, everybody, let's get back in. I'd like to call the meeting back to order. Okay. So at that last agenda item, that finishes our business and operations, and we'll now move to Section 6 of the Disability Committee. Can our Disability Chair, Paul Lotz, can you provide us your report, please?
Yes, thank you, Lisa. The Disability Committee met yesterday and approved the action items on today's Disability Committee's consent agenda. We will discuss consent items 1 through 4, and then the board will vote on these items as one motion. Are there any action items the board members would like pulled for a separate vote? Chris? What? Perhaps I could read through the 4, and then we could.
I think he does want it pulled so you can vote separately.
Okay.
Okay.
Sounds good. Okay, I will read.
So let's do 2 through 4.
Perfect. Staff's recommendation to approve the non-industrial disability retirement application of Josephat Leyva. The committee approved Mr. Leyva's application for non-industrial disability retirement, as his application was supported by evidence of being permanently disabled, not being attributable to work-related duties and causing the need for his leaving employment. Are there any questions from the board on this item before we move to consent item 3? Moving to consent agenda. Item 3, staff's recommendation to approve the industrial disability retirement application of Kevin Mayer. The committee approved Mr. Mayer's application for industrial disability retirement, as his application was supported by evidence of being permanently disabled, being attributable to work-related duties, and causing the need for his leaving employment. Are there any questions from the board on this item before we move to consent item 4? Moving to consent item 4, staff's recommendation to refer to hearing the industrial disability retirement application of Arsenio Ortinez. The committee approved sending Mr. Ortinez's application for industrial disability retirement to be considered by a hearing officer to determine if the Mr. Ortinez medical condition was caused by his work with the City of San Diego. Are there any questions from the board on consent items 2 through 4? Was it, let's see, actually 1, 3, and 4.
No, 2
through
3,
4.
and 4.
Thank you. Any questions before I move to approve the disability consent agenda? Okay, go here to current. I move to approve disability committee consent items 2 through 4. Please cast your votes. And this finishes the votes on 2 through 4, and we have removed item 1.
And Mr. Chair, if I may, just for the record, this motion passes 12-0 with all votes in.
All right, now we can move back to consent item number 1. Chris, is there anything you'd like to say about that before we vote separately on it?
No, thank you.
Okay. Find my place here. So we will vote separately on the to deny the industrial disability retirement application of Joel Mojica. Yesterday, we had a vote of 4-1, and Chris has requested to have that pulled for a separate vote right now. Do we have a motion to approve the denial of Mr. Mojica's application for industrial disability retirement? Moved by Christiana. Please cast your votes.
And with all votes in, Mr. Chair, this motion passes with 11 yeas and 1 nay.
Thank you, Rosie. This finishes the Disability Committee action items. Staff presented 2 information items for the committee's consideration and education. The committee reviewed Board Rule 7.180 and discussed changing the disability effective date rules to align with how county retirement systems also have the option to use the last date of the employee's compensation. The committee felt SDCERS their existing rules remain most appropriate and do not recommend to change the rule at this time. The committee also discussed the plan sponsors' workers' compensation program and how that is similar and different from SDCERS disability program, and what worker compensation information SDCERS can rely upon in making its disability benefit eligibility determination. The committee directed staff to ensure the SDCERS panel physicians are informed of not only the municipal code, but also SDCERS board rule on substantial cause. Moving on, staff provided a disability status report, and it is available in the board agenda package. And the disability report provides an overview of the disability application review, statistics highlighting the caseload is in good shape with a caseload of 20 applications, with all but 1 case within the 18-month processing window, which has been delayed due to the member's non-related health condition. Are there any questions or comments from the board members or staff? Okay, if none, our discussion is complete. So thank you, board members. Thank you, Chris, for that. And back to you, Lisa.
Okay, well, thank you, Paul, for your committee report. We'll now move to Section 7, Business and Governance Committee. So I'll return to our committee chair, Bobby Spoon, to give us a committee report.
Thank you. The Business and Governance Committee met yesterday, and before I review the action items and make a motion for the consent agenda approval of action items 1 and 2, are there any action items the board members would like pulled for a separate vote? Hearing none, starting with consent agenda item number 1, staff's recommendation to adopt a calendar year 2026 board and committee meeting schedule. The committee recommends adopting our standard meeting schedule for our board and standing committee meetings. With regard to the board retreat, staff will survey the board for a good date in April 2026 and do the same for board networking events, which we anticipate will be held in the spring, perhaps in March, and in the summer, perhaps in August. Are there any questions or comments regarding this item? Okay. Moving to consent agenda number 2, the recommendation to amend the noted charters, policies, and rules. Staff's recommendation to amend the overpayment and underpayment of benefits policy, the underpayment and overpayment of the contributions policy, Board Rule 6.60, which is the member to enter drop at the beginning of the pay period rule, Division 1 of the board rules, and Division 10 of the board rules. Johnny presented this item and highlighted the proposed changes to the over and underpayment policies and Rule 6.60. The committee unanimously approved the recommended changes to the various policies and rules. Are there any questions from the board on this item? Hearing none, I move approval of the consent agenda items 1 and 2. Please record your votes. I guess I need to vote. Thank you. We then heard reports from,
Madam Chair, if I may just announce the results of the vote. With all votes in, this motion passes 12-0.
thank you. Thank you, Rosie. Thank you, Paul. We then heard reports from Natasha on member services, from Sandra on benefits administration, from Michelle on IT, and we were very fortunate to get a September presentation from Ted, which was very highly unusual. Thank you very much for all of your reports. Are there any questions or comments? If not, back to you, Lisa.
Okay, thank you, Bobby. I will now turn it over to Cliff Sherishon, the Investment Committee Chair. Can you please provide us your report?
Thank you, Lisa Marie. I'm happy to. The Investment Committee met yesterday afternoon and discussed 5 action items and 1 information item. All 5 action items are on the consent agenda. Every one of these was approved at yesterday's meeting with a 6-0 vote with no abstentions. We're going to have a brief presentation on action item number 4, which covers the investment policy statement annual review and recommended changes. And for this, we're going to ask Katie Comstock to come forward. Before I turn this over to Katie, however, would any board member like to pull an agenda item for a separate vote? Hearing none, over to you, Katie.
Good morning, trustees. Thank you for having me. I'm going to give a brief overview of the annual investment policy statement that we review on an annual basis. This is among the most important documents that you all as trustees oversee, review, and approve as fiduciaries to this pool of assets. Now, this is a living, breathing document. Once it is well written, which yours has been, we don't really expect frequent changes. Usually at this annual review, they are tweaks, updates. It should evolve with the marketplace. It should evolve with SDCERS circumstances. But typically, these are changes that we make that are in alignment with asset allocation updates or structural updates. Now, we did include a red line version, and there are a number of more additional red lines this annual review than there have been in some of the prior years most recently. And that is because we took an opportunity to take a fresh look at the IPS and see if there were areas for just general cleanup, identify if we can potentially streamline the IPS, identify where things may be a little bit redundant, and improve really the overall flow of the document. One of the key factors that we view of a well-written IPS is the clarity of it, the brevity, conciseness, and so fiduciaries and stakeholders can find the information that they're looking for. So what I would do, what I characterize the changes of this year's review into 3 main buckets. One is to codify and formalize the changes that were approved by the board in the July meeting related to asset allocation. This includes benchmark changes as well. The second is related to the structural review that was discussed in length at yesterday's investment committee meeting, and that is on the consent agenda, and again, to formalize those changes in the IPS document. And then the third is kind of that general cleanup and just taking a fresh look and seeing if there are ways to enhance the readability and the way that the IPS flows. So I'm going to hit the changes. We have a memo in here that kind of highlights these, but to the extent there are any specific questions on the red lines, I'm happy to address those as well. So on page 3 of the memo, again, the asset allocations relate to the asset allocation changes relate to the policy updates that were made in July, and these are listed out here. The first being switch to a total public equity policy and adjust the allocation to 38%. This includes increasing, diversifying, and the infrastructure asset classes from 4% to 5%, decreasing real estate from 11 to 10%, and then adjusting the approach to the opportunity fund to have a strategic 0% target in the policy. Again, these are all changes that were approved at the July asset allocation study. Along with that, we needed to update the rebalancing policy, which goes along with the asset allocation, so that there's sufficient flexibility for market movements, but also guidelines for for the investment staff to rebalance the portfolio to stay aligned with the strategic policy that the trustees have set. There are also a few minor benchmark changes that we made in the IPS. These were also discussed during the structure review during the investment committee meeting yesterday, and I'll highlight them. One is assigning the total public equity benchmark as the MSCI All Country World Investable Market Index. This is a broad representation of global public equities and representative of the opportunity set for public equity. The second is an adjustment to the private equity benchmark. The private equity primary benchmark will still be a peer-based benchmark. The recommendation was to switch from the MSCI Burgess to a Cambridge. Both are institutional quality peer benchmark providers for private equity. Cambridge has a little bit of different methodology on calculation. It is used by a number of your peers, and so we'll be switching to that benchmark starting 10/1. The next is for really the bank loan portion of the return-seeking fixed income benchmark and the private debt benchmark. This is really just a vendor change, and the recommendation is to switch from the Morningstar Leveraged Loan Index to the S&P UBS Leveraged Loan Index. And again, this is more of just a licensing issue. Both of these indices cover the same market. We've looked at the risk-return characteristics, and they provide the same benchmarking evaluation that is needed for these benchmarks. And then the last one is for the Opportunity Fund. We'll be updating the benchmark to reflect the rest of the total fund policy. Again, this is to reflect the opportunity cost from investing away from policy for ideas that may fit within the Opportunity Fund. It had been the total fund excluding fixed income. To simplify that and to really show the true role for the Opportunity Fund, which is to invest away from your strategic policy using the total fund as the opportunity cost, we think makes sense here.
Katie, quick question on the Opportunity Fund. I know you're moving to a zero position. Does that mean you're just going to simply reallocate some of the investments that are in there to the other appropriate categories, or is this involving an unwinding of part of that portfolio?
So no unwinding. Right now, you have two legacy funds in there, Davidson Kempner funds, that are pretty much in wind down mode. So right now, there hasn't been any ideas, any investment that we think have met that threshold to go into the Opportunity Fund. So right now, it's essentially a 0% there. I think it's 10 basis point allocation. So there's nothing in there right now, and that's something that your investment team and we keep thinking of. Is there something that's attractive that fits the bill to go into the Opportunity Fund? We would bring that to your attention.
So right now, it's just it's a name change, in essence.
Right now, yeah, the opportunity, that flexibility in the policy exists. The benchmark, we're just updating to be reflective of the total, the rest of your policy.
Got it. Okay. Thank you.
Welcome.
Paul, if I may, if the Opportunity Fund is to be, sorry to mix words up, really opportunistic,
right,
you shouldn't have a permanent allocation to opportunistic once in a 5-year period kind of thing that comes along like a comet.
Right.
So that's why the benchmark weighting, I think, makes sense, setting it at 0, but allowing up to 5% if we find it. So when you look at are you overweight or underweight or whatever it is, you're not forcing the hand of the team to be in things.
You don't have to be in it if you don't.
Right.
Because opportunistic, by definition, you could have 0 from time to time.
Thank you. Thank you. All right, the next set of recommendations came through the structure review that we completed yesterday. The first is adding some guardrails within the total public equity asset class. And this is really just to help facilitate the implementation of this asset class. As during the structure review, we looked at what is the appropriate level of active risk, active versus passive management. We want to target a global orientation, and this is just putting those guardrails around the subcomponents of public equity, U.S., non-U.S., and global, to ensure that the rebalancing maintains that strategic role that the board has approved. The second relates to real estate. During the real estate structure review, we made a recommendation to modestly shift the risk-reward profile from a 70% core and 30% non-core target to a 60-40 target. This was approved during the structure review, and this is just codifying that again into the investment policy statement and putting guardrails around those weights. And then the last kind of bullet here, this kind of blends with the third category of changes. And what we did in the investment policy statement was add an section on investment guidelines. In the current IPS, there were some comments around mostly the private markets on what the risk posture should be, how they'd be implemented. There wasn't anything in the main body that talked about the public markets, and it wasn't really a consistent approach. And so we built that out a bit to describe to readers what the role of each asset class is and highlight the investment, the risk reward kind of profile that we're targeting. So calling out core versus non-core, or the market opportunity set, how it will be accessed. And so tried to make that a little bit more standard across the full portfolio. The last thing that I'll comment on are the general kind of cleanup comments, and this is where most of the red lines come in. A lot of them look like we took language out, but it's not the case. Some of what we did was just reorder or restructure the IPS. One of the things is that the table of contents kind of expanded to 2 pages. We cleaned that up to be a little bit more concise. We did a little bit of reorganizing. We moved the governance section up to the top. We felt that's one of the more important things when reading an investment policy statement that includes the role of the board, includes the important fiduciary duty that you all just heard about, as well as the delegation and the authority that the board has. We did other kind of slight adjustments. We included your new private market consultant, that role into the IPS, so expanding. Currently there was a role for the private market advisors and the real estate consultant, but we broadened that to read private markets consultant and make sure that their scope and roles and responsibilities were included as well. And then just general kind of redundancies. Over time, there had been some areas where things were referred to twice and just general cleanup like that. But overall, the spirit and the way the portfolio is managed, the roles and the governance and the processes, none of that has changed. It was really just taking an opportunity to make this a little bit more streamlined and concise. The last thing that I'll mention before taking any other questions was that we are taking kind of a phased approach in this. We tackled the main body of the IPS, but as you may recall, you have in the appendix 2 additional policies that are included. One is the real estate policy, and one is the policy for the private market advisors. These are full policies that are included in the appendix, and the idea was to have everything in one place so stakeholders can come to the one place to find all this information. In those policies, there's a lot of repetitive information in terms of roles and responsibilities, objectives, benchmarks. So at the November meeting, we plan to work with the investment team and coordinate with your private market consultants to review those, to kind of take out that repetitive language. We do think there's value in having a little bit more guidance and guidelines in there on the private market asset classes. So there will still be an appendix, but we want to coordinate, of course, with your private market consultants and advisors to make sure that we have that language right. So we look to tackle the main body of the IPS, and then we'll come back to tackle the appendix items, as well as any updates that result from the structure review on the private market asset classes that we'll be tackling in November as well. So with that, I'm happy to pause and see if there are questions or any specific comments.
Katie, I have a question, and I don't know if it's better posed to you or Karina, but when we're talking about the benchmarking, I don't know what page that was, 1 or 3. Just in a general sense, when we start tweaking with our benchmarks, the fear is that we're just lowering our standards because we're not meeting them consistently. Can you help assuage that fear? Can you speak to why we're making these specific changes? And I'm curious if the aggregate effect is actually just lowering our expected returns or the returns we're trying to beat.
Yeah, absolutely. I can start if that's okay. So that when we look at benchmarks, we want them to be fair, and Callan went over some of this yesterday in the investment committee meeting, what defines an appropriate benchmark. And all of these changes meet those criteria. I would say for these, it's mostly changing kind of the provider of the benchmark rather than the actual meet in what we're measuring. So for instance, for the return seeking in the private debt, the risk reward characteristics when we compare these 2 indices are virtually identical. There may have been 10 basis points over certain time periods. So that metric and the role of that benchmark is not changing. I would say for private equity, this could potentially make it a higher bogey. Actually, Cambridge does have their primary consultant base is a lot of endowments and foundations that invest in kind of higher octane private equity. So some observations have been that it might be even a higher bar than the current peer benchmark, which has a broader opportunity set. It's still appropriate. It's still a diversified set of peer private equity funds. And another thing that you mentioned that I think is important, that the other common benchmark that you use as a secondary benchmark is a public plus a premium. And it's important that some plans have gotten into trouble if they switch between those two in the same benchmark, because that benchmark then becomes a lot less useful when you look to compare performance. So maintaining a peer benchmark or maintaining a public plus premium is kind of more important than the peer benchmark provider, because it loses the integrity of that benchmark. And so we had coordinated with Callan on those benchmark recommendations, and we're supportive, and we do not believe that you're lowering the bar by any means by these benchmark changes.
Thank you.
Quick comment, and I don't mean to disparage anything on the investment side, because I think you guys are doing just a fantastic job, including our own internal investment people. One thing that strikes me as I sit back here, not being on the investment committee and looking at this from 50,000 feet, is it's very difficult to understand, out of all the analytics you provide, whether this portfolio is putting us more in a conservative position or a more aggressive position. I don't exactly know how to get my arms around that, and I know you provide the Sharpe ratio and all that stuff, but it's difficult for me to assess as a layperson. Are you guys advising us moving into more of a conservative posture or less of a conservative posture? And it's tough to see it with all the detail that's being provided.
Yeah.
I'm not sure you can answer that today, but
I appreciate that observation, because you're right. The material today is definitely more into the weeds, into the execution. I think what would be best to answer that question would be to refer to the July meeting, or even the meeting before that, when we went through the asset liability study and the asset allocation study. And during those, the way that the slight changes that we're putting into the document for the asset allocation shifted the portfolio slightly more, reduced the risk, a slightly more conservative. It diversified the portfolio. Now, it was at the margin. When we looked at the overall profile during the asset liability study, you're in a really strong position. And so we felt your asset allocation was, there was no major changes needed in terms of where you're going, in terms of funded status and costs of the plan. And so there were slight tweaks that reduce the risk while not really changing the expected rate of return. And that's a favorable position to be in. You can't always do that, where you can maintain the same expected rate of return while reducing the risk. And so that's the direction of the last asset allocation study. And that is something that we'll look at on an annual basis, and can kind of show you how your Sharpe ratio, reward per unit of risk, kind of has shifted.
It'd be very interesting to take a look at that over the course of time, what's going on over the last 10 years and what the projections are, more importantly, moving forward.
Yeah.
And the reason I say that is I would anticipate that this fund is probably going to be from 14 or how many billions of dollars we are now, probably into the 20s in the next 10 years. We'll probably be dealing with a lot more retirees. And it's hard to understand, how do we prepare ourselves for that, given the current situation from a risk-reward standpoint?
Yeah. Absolutely. And then during the asset liability studies, we look at that and say, when we project out, looking out over the next 10 years, do we need to be taking this much risk? Do we need to be taking more or less? And what does that do to the other financial metrics? And that's certainly, we want to be looking out forward, because it takes time to shift assets for a large pool.
Yeah.
And so that's something that we're absolutely looking at.
Greg, maybe that might be a good topic to address in the upcoming offsite in March. Give people enough time to assess it. One other question on this, and I don't mean to.
No, go ahead.
Given all that has occurred, I know this is kind of a short-term window here, but it certainly appears, if you listen to the news or have your eye on the markets, what's going on today, that there are a number of concerns out there. The debt to GDP ratio is climbing high. We've got the potential of higher inflation coming up. We've got a lowering situation where the value of the dollar is declining. I think it's 10 to 15% over the last several months. What's your projections or thoughts, not projections, but thoughts moving forward? Should we be preparing for a recession at this point, or do you think the portfolio is positioned well enough at this point to weather any of those concerns you might have?
Yeah.
As a professional investment advisor.
Well, I think I would kind of summarize a lot of what you highlighted is that there's a lot of uncertainty. A lot of uncertainty on how capital markets are going to perform. We've continued to be surprised on the upside with how equity markets have performed.
With all these tariffs out there, what's going on? Why aren't they showing up in inflation?
Right. And so we are cautious. You know, Aon's kind of standard view or currently is that we don't think a recession is the base case, but we think the risks of a recessionary type environment have certainly increased. Now, in terms of how we're advising clients to position their portfolios is to add that diversification. We still think long-term public equities will be a bulk of the growth in the portfolio. That's still the largest allocation in your portfolio, and we think that that's appropriate. But you have done a significant amount of diversification in your portfolio by adding things like infrastructure and private debt, things that have an income component, and having 10% to real estate. These are all areas that not only have kind of an income, a more stable, someone can say recession resistant, but they're also diversified in the return profile as well. So your portfolio, when we look at compared to peers, your large public pension peers, is more diversified, has slightly less public equity exposure, because you've been kind of preparing for what we think is going to be an uncertain, potentially more difficult environment for largely the equity market. You also have your core fixed income portfolio that is there to protect when, your safety bucket, if we are to start to see some weak spots, that can also help up. You're getting yield from that now, so that's really nice to see. So based on all of that, we think that you have adjusted your asset allocation appropriately. And so there may be periods of weakness. We've seen tremendous 9% for your past fiscal year, north of 9%. That's exceeded expectations. So we wouldn't be surprised if we start to see some weakness, but we think you're diversified and you have to maintain that long-term perspective as well to kind of ride through potential periods of volatility.
And I know there's another question coming, but along those lines, as you mentioned earlier, Katie, this is not a little rowboat that you can turn quickly. We also have an obligation to take that long-term perspective. But I think it's a helpful question. I think it's on the minds of many of us of, gee, with all this, call it uncertainty, these factors that you rightly point out and others. Personally, I'm very surprised. I'm happy that equity markets in the United States are up as much as they are year to date, because new records almost every week, because you might have thought otherwise. So no one has a crystal ball. Chris, you have a quick question, because we have a lot to cover here. I don't want to talk about 6.5% right now.
No, but I wanted to talk about just mention what Lou was talking about, because I have the same concern as he expressed about what are the benchmarks here, what are we comparing ourselves to? And if you look at over the fiscal year ending June 30th, just a basic 75-25 passive investment in U.S. stocks and bonds returned about 290 basis points more than our diversified whatever. And last year there was even a greater delta on that. I totally understand the idea and the need for diversification. I get that. But against, what is the trade-off, right? And what mark are we trying to hit? I mean, are we trying to hit a lower mark based on the idea that we're willing to give it up for the diversification and I guess, supposed stability? And how much do we give up?
Yeah, and those are all very valid and and questions that are answered when we look at that asset allocation and asset liability study is, what are those trade-offs between hitting a return, illiquidity, costs, implementation, the resources and the time of the trustees and the investment team that you have when setting asset allocation. And the decision has been, and we think it's a prudent one, that diversification and kind of smoothing that pattern of return, which does, which does lower the humps on the positive side, but really importantly, it also improves the downside, the downside scenarios as well. And so those are all trade-offs that are evaluated during the asset allocation and asset liability study. And the long-term risk-reward trade-offs we think have been favorable relative to a more peak valley type volatile performance that you would have seen from a simple equity bond portfolio. Hindsight's 20/20, but we think looking forward, having that diversification will be important.
And I just wanted to add that there really is a stress on smoothing the ride. If we do, God forbid, hit a deep recession that continues on for several years, obviously you spread the losses over a period of time, but depending on the depth and the length of that recession, you may not be able, through the sequencing of returns, to essentially have your contributions unaffected. So what does that all mean? It means that your employers and your employees may have to contribute more if we go into a recession. So we're really trying to smooth that ride for the stakeholders here. We know that the pension is a big portion of the city's budget, and also it directly impacts employees too in terms of how much they're being asked to put into the plan.
Karina, can you just give a couple of examples of investments that would buffer us in a recession?
Absolutely. So this is what we want to have from the diversifying allocation. So we're literally here looking for investments that do not correlate to equity market beta. We've seen in a number of studies that equity market beta is the largest contributor to risk as measured by standard deviation. So that's essentially what we're trying to do. And these types of investments help exactly to smooth that ride. And it is also what we witnessed in 2022 when public markets sold off. We saw that we had good protection on the downside through these types of strategies. They are managed futures that are currently what we hold inside of the diversifying bucket. Now, managed futures in up markets like what we've seen just recently, they don't perform as well, and particularly not well in markets with quick reversals. So this is why also we're looking through the structure review to broaden out the types of diversifying strategies we are invested in and find something that is complementary to the managed futures holdings while still offering at the plan level lower volatility. And I want to go back to Paul's question in terms of overall, what are we doing? What is the impact up or down on risk? The highest level is more on the asset allocation side. And there I would say adding a private debt as opposed to private equity, that would have been a risk reduction move. I would say that adding infrastructure, lowering real estate, that would also be a risk reduction move. I would say increasing diversifying would be a risk reduction move. And then on the structural side, which is sort of a secondary, not as much of a primary impact as the asset allocation, so more on the margin, you're getting a slight uptick in active risk by increasing global equity, which we've decided to invest 100% actively from 17% to 20% within the global equity portfolio, so very marginal change. And again, a slight increase in risk on the real estate portfolio, moving from 70% core to 60% core. So the structure is just a slight tweak, if you will, on risk. The bigger picture pieces are risk reducing, which the asset allocation study underscores. It drops the overall projected risk.
That was a good breakdown. Thank you.
You're welcome.
All right, I'm going to ask at my peril.
Just one thing, Karina, that was very clear. I'm not sure what we need to do, but it would be very helpful, I think, for the board if you somehow, you and the investment teams could summarize that in a brief 1 or 2 page memo that gets included in board packages periodically. It's kind of a, message from the CIO.
Absolutely.
Because we're not getting enough backup material so far. For
No, the backup material is great, but it's awfully analytic.
Yeah.
And it's tough to see the big picture of what is driving this thing. Yeah.
Another thing we can do, I think it's been talked about before, as we come to the end of this cycle with the asset liability study, the asset allocation study, and the structural review, you can also do a look back analysis and see how you've done. Now, of course, as Katie's mentioned, this last period has been obviously very robust equity market returns. But we know, for instance, that when we chose to broaden out our return-seeking fixed income allocations beyond just emerging market debt, we know that was very additive to the plan. High yield and bank loans performed significantly better than just emerging market debt in this last period. So we know, for example, here we've made a change, and sometimes it feels like we make a lot of change, but here we know that the change paid us. And so that we could do a study that shows, were these actions value additive, yea or nay?
Thank you. Sorry, Cliff.
No, it's fine, it's fine. Is there any other topic of discussion about the consent agenda before I move for approval of consent agenda items 1 through 5?
I would just like to make a comment. I'd like to thank and thank you, Cliff and Katie, because I was the one that asked for the more detailed report instead of just a consent vote on the investment policy. It is one of the most important action items that we take, and obviously I'm a member of the investment committee, but I thought it was important for all of the board members to participate in this discussion. So thank you for indulging me.
Well, no, I think it's to everyone's benefit.
And with all votes in, Mr. Chair, this motion passes 12-0.
Thank you very much. There is one important information item, which has to do with the total fund performance for the quarter ending June 30, 2025. The SDCERS total fund returned 5.3% net in the second quarter of 2025, posting a strong absolute return, but modestly underperforming the benchmark return of 5.5%. For fiscal year 2025, the total fund returned 9.4%, which modestly outperformed the benchmark return of 9.3%. The fiscal year return was driven by strong absolute performance in the majority of asset classes. The Sharpe ratio for the total fund is in the second quartile over the past 5 and 10 years compared to similarly sized public pension plans, indicating attractive risk-adjusted performance over longer time periods. And there is a lot of analytics in your package on that as well for those who are interested. There are a lot of reports on a number of, for me at least, interesting topics. I would also point out very quickly that in addition to Aon's presentations yesterday to the investment committee, we also had presentations by our real estate consultant, Makita, and Callan, our private markets consultant, in one of their first presentations in their new responsibility. And with that, back to you, Madam Chair.
Okay, thank you, Cliff, for the committee report. We'll now move to Section 9, question and comments. And before I ask for any comments from the board members, I'd like to ask the board's ad hoc executive search committee chair, Michelle Bush, to provide a brief update.
The ad hoc committee for the succession planning for the chief executive officer met on Monday, August 4th. I'd like to thank Chris, Lou, Louie, and Greg and Colin for supporting the committee members. We discussed the roles and responsibilities for the community as well as a high-level succession planning timeline. And we're going to be meeting in November to discuss emergency succession planning policy, which we'll bring back to the board for adoption.
Okay, thank you, Michelle. Are there any questions for Michelle? Okay, are there any comments from the board or any education session report outs that the board members would like to share? No? Okay.
As many people here know, I serve on other boards, and some of them are in the mutual fund space. And the industry lobbying and support group for the mutual fund industry in the United States has a large series of educational webinars and sessions. And one in which I participated recently was about blockchain and crypto. And I found that base level of education on those topics to be very, very interesting. It didn't strike me as anything that is a call for action in any particular way, but I think that that's a topic that may be something that the board and staff may want to learn more about. Of not only does one invest in crypto or not is not a topic I'm interested in personally, but how can we do our jobs better? Those of us on the board, those of us on staff, other stakeholders, and are there other implications as we look forward, because we do have decades of the future to think about. So I'm sure there's a lot of different resources that one could consider for something, and I just thought I'd bring it up as a possible topic.
Maybe at a future retreat.
Exactly.
So Greg, can you make a note of that?
Noted.
And I do have a question for Rosie. I know we just adopted our 26 calendar. Are you going to populate our calendars with all those dates?
Yes, I sure will, Madam President.
Thank you. Are there any questions or comments? No. Go ahead, Greg.
All right, thank you. To begin my comments, I would like to recognize Lisa Marie's daughter, Camille, for earning her doctorate in computer science. Well done, Dr. Harris. I would also like to recognize one of our embedded information technology contractors for supporting our SDCERS environment, our board, and our staff. He's such a nice person. We just all know him by his first name, Alfredo. He has been nominated for Employee of the Year by his employer, Zensar, in the category of Annual Excellence Innovator of the Year. And his citation on how he helps SDCERS is too long, so I'll just sum it up by saying, thank you, Alfredo, for all you do. I would like to recognize Ted LaSalvia and the accounting team, along with Natasha Kalura and the member services team, for being awarded the Certificate of Achievement for Excellence in Financial Reporting. A special shout out to Fong Win, who's responsible for the reporting statement package, and to Jessica Taylor, who's responsible to make it all look pretty. This is the 21st year receiving the award for SDCERS, our 17th in a row, and importantly, the 12th in a row for Ted. Thank you, Ted. I would like to recognize our member services team for their hard work on a special project to safeguard our member information by scanning a mountain of historic paper documents amassed over decades. You may recall this is part of our action plan. For years, no one really wanted to tackle this project because it was too daunting of a task, until a special group of people came together, and they are crushing it. In 1 month, they scanned over 47,000 pages, which is about 4 months of standard level scanning. Wow. They really even crushed the single-day record scan that had stood for 3 years by scanning over 17,000 records in 1 day. Nice work, Liz and Thomas. So thank you, and this is in alphabetical order. Andres Molina, Jennifer Webb, John Hansley, Liz Diaz, Michael Ramirez, Monica Rios, Natasha Kalura, Thomas Sanchez Suarez, and Victoria Fedeliso. In closing, I would like to recognize the 7 SDCERS employees who participated in the City of San Diego's Worldwide Wellness Challenge and elevated SDCERS to a 16th place finish out of 36 departments. Honorable mention to Sarah Levy, Nayeli Sanchez, Natasha Kalura, me. Special recognition to Melanie Peter, who tied for 5th place overall. A spectacular podium finish to Jessica Taylor, who tied for second place overall. And who do you guess won gold, tied for first place overall?
Charlie Tran.
Close. Well done, Jamar Montgomery. Thank you. That concludes my remarks.
Okay. You have a comment?
Yes, please. I just wanted to thank the board. One of the things you approved today in the packet was the change in the corrections policy. And I get a lot of feedback from the retiree organizations, and that is one of the things that really hangs over their head of what would happen if all of a sudden they found out my benefits were wrong and what would I owe and so forth. And I know we did a lot of work to discuss this and where should we be. And I just want to thank you on behalf of the retired members for recognizing that situation and I think addressing it in a way that is going to protect them as well as the fund to a reasonable extent. So I think you should, among other things, leave this meeting feeling like you've done good on behalf of the members. Thank you.
Thank you, Chris. So we're going to move to Section 10, closed session. Johnny, do we have any closed session items?
We do. We have lots of closed session with
Okay.
current litigation, anticipation litigation, as well as a public evaluation of the Chief Executive Officer and Chief Compliance Officer.
Perfect. So the board will now be going into closed session. For staff, consultants, and visitors not invited to participate in the closed session, I'd like to ask you to leave the room. Rosie, please stop recording the meeting while we were in closed session. Thank you.
What time's the chow show up?
Yep. Yeah, we can go and take a break. And Rosie, you're going to bring in the lunch, right?
You don't know what they're looking for. You just, they don't. But anyway.
Okay, is Rosie? Rosie, you got everything ready?
Yes, Madam President, we are ready.
You're ready? Guess we should wait for Greg to come back.
He's not coming back.
Oh, that's right. Even during the public, because he
Yeah,
can watch it on TV.
He chooses not to, yeah.
Even though it's public, he's not supposed to be here.
That doesn't make sense to me. Okay, I would like to recognize SDCERS Human Resource Director Colin Brazil to present the salary survey information on the CEO.
Thank you, Lisa Marie. So each September, it is the board's responsibility to determine whether or not a salary increase is appropriate for our CEO in the open meeting. We've come to that time. I provided you with a salary survey to help you make your decisions and for information of different CEO salaries up and down the state, in the retirement systems, similar size, some smaller, some larger. If you have any questions on that survey, I'm here to answer those. But at this time, I would like to know if anyone would like to discuss a salary increase for Greg at this time.
Well, I think given that the city has already made an adjustment of 7% since January, that I'm not supporting a salary adjustment. Are there any board of directors that are interested?
No, I would support that as well.
Okay.
Thank you for your consideration.
So thank you. We're now moving to section 13, adjournment. Are there any other questions or comments that the board has? No? Okay.
Yeah, I do.
Go ahead. You always have something to say.
Before I start calling him Greg.
There is an event on October 10th. In the invitation you received, there is specific reference to the cuisine. If anybody is, I've already heard from one member that that's not perfect, that is, they don't eat that. And so.
Well, they can choose not to eat it.
So, no, we have the flexibility to accommodate your tastes. So please let me know if you have a dietary restriction of any sort, and we will accommodate. But you have to let me know in advance. Thank you.
Thank you, Chris. Are there any other questions or comments? Okay, so our next regularly scheduled meeting will be on November 14th, and I will see you all there. Thank you.
Thank you.
We are adjourned.